SJC-08737, Commonwealth versus Daniel Holland.
Mr. Dixon, good morning. Give us a second. And you may proceed.
Morning, Your Honors. Kevin Nixon for Mr. Holland. Mr. Holland on appeal raises a single issue, the denial of his first motion for a new trial. And the reason that that's important is because Mr. Holland at trial had only one defense. The only thing that tried effectively was his mental state. There was evidence in the case of gross intoxication. Mr. Holland testified to that fact, and there were other witnesses who testified to the same effect. And Mr. Holland, after the fact of his conviction, then began to complain to the extent that's raised in the motion for a new trial about trial attorneys having overlooked what he had told them about his mental illness that dated from the time he was a teenager.
Can I ask you
Yes,
why
Your
it
Honor.
is, if this trial took place in 2001, that it's on direct appeal now? And so this is 15 years after it was entered in the trial court, 10 years after the new trial motion was filed, and 8 years after the motion was decided.
Yes, Your
Why
Honor.
is it just now before us?
I'm the third appellate attorney, Your Honor. I was appointed to this near the end of 2011. My predecessor retired and moved to Maui. His predecessor developed some problem that prevented him from proceeding with the case on appeal. To get into more than that about what has held it up since I took the case in November 2011 would require, I think, breaching attorney-client confidences, Your Honor, and I'm reluctant to do that without a waiver from my client.
Okay.
So what happened is that Mr. Holland had told his trial attorneys about his mental history. They did nothing with that fact, despite having obtained funds.
This was 17 years prior, is that right?
That's right, Your Honor.
Okay, and Attorney Carney and Attorney Jubenville looked carefully into this defense, didn't they? And decided to go in a different direction?
I assume that they looked into it, yes. I don't know how carefully they looked into it. Mr. Holland, at the trial level, was also going through a series of attorneys that and he says in his affidavit, and he said on the record in front of Judge Conley at some of the pretrial hearings, that he was firing them because they were not following his advice to investigate and develop his mental illness, evidence of his mental illness.
Judge Conley, though, even though we sent him for a competency evaluation, thought that on the day of trial, when Attorney Jubenville was representing him, that he was, I think Judge Conley said, manipulating the system. I think
He did. In fact, he mentions that in his memorandum of decision denying the motion for a new trial, that had been the constant, a persistent theme with Mr. Holland's appearance in the trial court. Yes, Your Honor.
Now, in connection with the new trial motion, what expert opinion was offered as to the defenses that he says he was deprived of?
Dr. Joss, who did testify at trial after he was contacted mid-trial by the trial attorney.
Mr. George.
Yes, yes. Trial was underway when Joss got the call from Attorney George to come down and examine, speak with Mr. Holland, and examined a sheaf of documents that had been supplied to Dr. Joss. And because he was a psychologist, he was only permitted, once he did form an opinion, to offer an opinion about the effects of alcohol and cocaine intoxication and prescription drugs too. Mr. Holland had said that he was taking a lot of Elavil with his alcohol at that time.
What about mental illness?
He did not form an opinion.
That was at trial.
That was a trial.
But how about the opinion
Later,
relating to a motion for a new trial, like what I would have said if I had had
Yes,
the
there's
chance
an,
to say it. He doesn't really comment on competency or mental status or anything like that, does he?
no, he does not, Your Honor.
You don't
He's-
really have an opinion supporting the motion for new trial that suggests what it was that would have happened had an expert been retained or, I mean, there's really nothing to go on in terms of what diagnosis would have been given.
The opinion that the motion really rests on is the client's own opinion of what his mental state was. The expert opinion that's in the record in support of the motion for new trial from Dr. Joss is that the attorney's failure to obtain the documents that he saw later impaired his ability to inform the jury to a greater extent than he did what the likely mental effect, or likely mental impairment was that Mr. Holland was suffering.
What about, how is it effective assistance of counsel to engage an expert after the trial started? I don't understand how that is not part of what you went back to the judge with on the motion for new trial.
Well, that's part of the presentation, yes, Your Honor. That it's only after the case is, or the trial's underway that Joss comes and meets, briefly with the client. I think he says he spent about 90 minutes with him. And he wasn't able, because of the sort of short leash he was on, to, do much with the information that he had in terms of documents or what the client had told him.
Oh, okay, I didn't understand that part of your argument was ineffective assistance of counsel.
But he got those materials prior to the motion for new trial
He did, and he got,
for him, and he still didn't give an opinion.
well, he got other materials that one of my predecessors had obtained from some health providers that the trial attorneys had not obtained.
And presumably, he could have had access to the defendant and spoke with him further if that had been arranged,
Yes.
but that didn't happen.
No, it did not happen, Your Honor.
Okay.
So how do we reverse this conviction?
The defendant's position, Your Honor, is that a substantial likelihood of a miscarriage of justice was created by counsel's inaction in not investigating and presenting evidence that was available to them of the defendant's longstanding mental illness. And if the jury, which heard a lot of evidence about how grossly intoxicated he was on the night of the killing, had heard additionally that he was suffering a mental illness, which was, of course, interacting with the level of intoxication that he was under, they would have returned a second-degree conviction instead of the first-degree conviction. This case was never tried for a not guilty. It was a mitigating defense asking the jury to return second degree instead of first degree.
Now, apart from your client's own opinion, were there existent psychiatric records that showed a particular diagnosis?
Diagnosis is probably too strong a term. He was really only under a doctor's care at this level as an inpatient when he was in his late teens. And there's an indication in the record that was presented to the motion judge showing that he does have borderline psychotic, my sister should be able to correct me if I've got that wrong, but there was sort of a tentative diagnosis that wasn't really completed to the extent that you would expect if he had been seen for a more sustained period of time or later in his life.
And that was one inpatient
There was
admission?
one period when he was a teenager, and I guess he was having a lot of problems. He was, and the record shows him at that time, and later he reiterates that even as an adult, he heard voices and was moving as though through a dream on the night of the killing.
That's a self-reported.
Self-reported, yes, and recorded in the documents that were created when he was a teenager.
Is there any affidavit from previous counsel indicating that information was provided to counsel?
The affidavit is from Attorney George, and he, in large part, can't remember what he did or didn't do. He says that there was no reason for him, to, of course, to not present evidence of mental illness if he had learned of it. It would have fit perfectly within the theory of the defense. The other attorneys, Jubenville's involvement is, I think, pretty well spelled out by the record. He withdraws with the client, insisting in open court that he wants him out of the case because he's not doing what the client has demanded in terms of investigating his mental history. As far as Attorney Carney goes, there was a very contentious, lawsuit between Attorney Carney and Mr. Holland. Mr. Holland sued Attorney Carney, and I don't think the attorney who presented the motion to the judge expected to see an affidavit from him. I'm happy to answer any other questions. Thank you very much.
Thank you. And Mr. Nixon, it appears you have a challenging client, so we do thank you for your representation.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this Court to affirm the defendant's conviction for the first-degree murder of Elizabeth Holland and for armed home invasion. The evidence that the defendant committed these crimes was overwhelming. It involved his DNA on the beer can at the scene, the rifle with a serial number that came back to him, his golf bag through the broken window in the home, neighbors having heard loud noises and seen a man leaving the scene at the approximate time of the murder. Counsel in this case made a reasonable strategic decision to pursue a defense of impairment due to intoxication by alcohol and drug use. The defendant's long-term drug and alcohol use, there was substantial evidence of that in the record. The defendant himself testified for 3 days about his history of using drugs and alcohol, so much so that during the defendant's testimony, there's a remark from the prosecutor that we're now in the 5th hour of hearing from this witness, and we haven't even gotten to the month of the murder.
But I hear from Mr. Nixon that he's not saying that counsel was ineffective for failure to maintain a criminal responsibility defense. That's not what he's saying. So it's not a strategic choice here. He's saying that the attorneys could have bolstered the defense he chose to present, which was the diminished capacity defense, by adding onto it the juvenile history, which he says would have reflected some evidence of psychosis.
Looking at the records that have been provided, they do not reflect evidence of psychosis. They are 17 years old at the time of the crime. So certainly it would have perhaps diluted the alcohol and intoxication defense. The suggestion that counsel did not investigate his client's so-called history of mental illness, again, is belied by the record. Years were spent by the Commonwealth and the defense negotiating what discovery would be provided to the Commonwealth relative to the mental health defense, with Mr. Carney opposing efforts by the Commonwealth to get certain records, and then Mr. Jubenville was in the case for an amount of time, at which point the court authorized neurological testing, the CT scan and the EEG testing of the defendant, even though it was not medically warranted, in order to move the case along. Those results came back as normal. The defendant was evaluated for competency at Bridgewater State Hospital immediately before the trial. That came back as he was competent, and there was a suggestion of malingering. There's never been a diagnosis of any major mental illness that this defendant had that would be something to be brought before a jury that could have possibly affected the outcome of this case.
Okay. In other cases, it has been a question of whether or not pursuing a mental illness tack in addition to intoxication would dilute the defense, but the defense would really have to do with, wasn't it self-defense in the other cases? Here, it wasn't, there really wasn't that. What would it dilute? Assuming that there was a mental illness that could be raised.
Well, that's sort of the issue is there really wasn't. There was no diagnosis of any mental illness. There's the defendant's perspective, I guess, that he had a mental illness, but there really wasn't.
Well, he'd been hospitalized, hadn't he?
He had been in his youth. There had been some sort of legal problems that resulted in him being in DYS custody, and review of those records shows that the concern, it appeared to be, was with his parents and with his family. There was no formal diagnosis. There is the statement of he appeared to be bordering on something, but there's no further diagnosis and there's no further record suggesting that he did not have that illness.
And no indication that he was on prescribed medications for anything having to do with a mental illness?
At about 6 weeks prior to the murder, the defendant had checked into a rehab program. He had gone to South Shore Hospital and then been admitted to a detoxification program. And I believe he was prescribed Prozac as a result of that.
Okay.
And then later there is the testimony that the defendant and his girlfriend went to the Winnebago and found some prescription medications. But again, the only evidence of him being prescribed something was the suggestion that he might have been prescribed Prozac by the detox program.
Okay.
Your Honors, in this case, we would ask that the court affirm the conviction. Again, there is overwhelming evidence that the defendant committed the crimes, and there is no substantial likelihood of a miscarriage of justice based on the performance of counsel.
Okay, thank you.
Thank you, Your Honors.